The first thing that a buyer needs to understand about entering into a property transaction is that everything has to be in writing. This is underpinned by the legislation that governs the property sale transactions and the actual transfer of property. And it is a bit archaic that we can't do it digitally, but at the very least, there's enough case law to let us all know that it has to be done in writing, it has to be signed in wet ink, and there has to be all the necessary details there in order to be able to ascertain what property you're buying, what your name is, what the seller's name is, what the property description, and any other conditions. But most importantly, has to be in writing, has to describe the property, has to describe the parties, and all parties need to have the necessary authority to be able to enter into this contract. So that sounds simple enough. But the next step that one needs to undertake is, what other content does this agreement actually have? And unfortunately, this is what makes or breaks a deal. Knowing the property, knowing the purchase price and the parties, that's the easy part, right? But now the question is, well, what are the other terms and conditions that we enter into? And I feel that this is very crucial for buyers to understand, because they might be caught unaware. As an example, if you buy a property and you look at the condition of the property, what does that mean for you as a buyer? Are you buying the property in the condition that it's in? Is there an expectation on the seller to repair certain things before you take transfer of the property? Well, where's this written? And simply writing at the bottom of the contract, the sink is broken, is not going to create an obligation for the seller to fix it. It simply just states the obvious, that the sink is actually broken. So what do we do about it? What are we doing about that sink? Another example, tenants. You buy a property, does it come with the tenants? Doesn't it come with the tenants? Now, our law requires that if a person buys a property and there's a valid lease agreement, that the new owner actually take on the tenants. But is this what you want as a buyer? So you have to be aware of this. The contract needs to stipulate what is expected of you as a buyer, what is expected of the seller as a seller. So the condition of the property is a very big one. Tenancy is a very big one. And then another huge one is, how exactly are you going to pay for this property? Because at the end of the day, how you pay for the property will make or break the deal. If the bank doesn't give you money, you can't pay for the property. Now, what happens if you enter into this contract and the bank doesn't give you money, and now you're stuck in the contract and the agent wants to sue you for estate agent's commission? Maybe the seller wants to sue you for damages. What does this contract say about that? So these are very, very important principles that you have to keep in mind. And this is what's called the OTP, otherwise known as the offer to purchase, or the deed of sale, or the sale agreement. There's many different names for the same thing. At the end of the day, it is the same thing. You're buying a property for a purchase price from somebody else. So whatever name it has is inconsequential. What it looks like is what matters. So once the OTP is signed, we typically tend to find that the purchaser's role and the seller's role is actually now handed over to professionals. So the upside for you as a property buyer or property seller is, at this juncture, there's a lot of assistance that gets offered by these professionals. Now, for starters, obviously the buyer, as Ntabi Singh said, needs to apply for a bond, presumably if they're using the bank in order to finance the property. So what does this normally mean? You approach your banker, you approach the bank directly, or you approach the mortgage bond originator. These are the role players that he's saying, whose job it is in order to verify your credibility, assess whether you can afford to take out a bond, and actually lend you the money. Now, right at that point, if we just look at the financing side, as soon as the bank says, yes, I will give you a bond, immediately after that, there is something that's called a bond attorney that is going to be appointed. Now, this is very different from the conveyancing attorney. right? So these two attorneys are typically approached at around the same time when the bond is approved. Why? Because it's only really when the bond is approved that we know the transaction's going to go ahead. So it's at this time that the conveyancers will typically want to jump in, and the bond attorneys will typically want to jump in because they both have their own jobs to do. Now, what are those jobs? The conveyancing attorney's job I will explain as I go through the process. The conveyancing attorney runs the entire transaction. They are the attorneys. The conveyancing or transferring attorneys are the attorneys that move the property from person A to person B, right? Now, the bond attorneys that work together with the conveyancing attorneys and sometimes might actually even be the same firm of attorneys, their job is to protect the bank or the bondholder. So the bank is obviously the financial institution, and for them to lend you the money, more often than not, they're going to want to mortgage the property. All that means is that the property stands as security. And for that to happen, you need a bond attorney to register a bond. And that's all we really need to know, is that there's a bond and there's a special attorney that goes and registers the bond against that property. They work hand in hand with the conveyancing attorneys, but they've got a limited function. They just want that bond registered. So by the time the property registers in your name as a buyer, they want that bond registered. They are waiting for the transferring attorneys to register the property in your name so that they can simultaneously register a bond. So as this appointment happens, you're going to find that the transferring attorney's job starts kicking in. So now the next phase. What's the next phase? So they're aware that there's a bond attorney. They're aware that that's a bond. What does the conveyancer do? So typically, the most common steps in the process at this juncture would be to find out, all right, well, what is outstanding on this property and what certificates do we need in order to be able to proceed with the transaction? So here you start asking the question over, is the municipality owed money? And if so, we need the seller to pay the money, and we need the municipality to give us a figure that will allow us to get a certificate from them to confirm that all the money has been paid. Now, just remember, this often includes projected amounts going forward. Why? Because the transfer doesn't take place instantly. A transfer can take 3 months, 6 months, whatever it might take. So you will find that the municipality, for example, will project a figure for that period of time so that by the time the transfer takes place, there's a zero balance outstanding. And yes, if there's a little bit of an amount here and there, credit, it's perfectly fine. The amounts get refunded. So you'll often find that the amount is slightly high and there might be a refund and that the certificate lapses at a certain time. Same principle will apply to body corporates and to homeowner associations. Exactly the same as a municipality. So if the seller owes the body corporate money, the conveyancer is going to knock on the body corporate's door, is going to ask how much is owed, as well as how much do you want us to pay you to cover the delay in transfer. Homeowners Association, exactly the same thing. Now, why is this? Because all these entities, all these associations require their debt. It's actually sitting in the law. So the municipality, there's an act that says it has to be paid. Right? The last 2 years of debt has to be paid before transfer can go through. And the body corporate also gives that entitlement. The body corporate has to be paid. There has to be a certificate. They'll only issue that certificate if the debt has been paid. Homeowner associations, it's normally in your title deed as a homeowner to say that this property cannot be transferred until the full debt has been paid. So a body corporate governs a sectional title scheme and is the grouping of all the owners that make the decisions on behalf of the sectional scheme. A homeowners association is usually a voluntary, at the beginning it's a voluntary association that begins with freehold properties most commonly, but there are also sectional schemes within the homeowners association. And this you find isn't governed by the same legislation, so all the rules and all the limitations and restrictions are actually found in the title deeds of the freehold properties that are grouped together and normally walled off, and everyone agrees to pay levies in order to be able to provide for security. So you'd find that security estates, typically, that have their own gardens and their own roads, these are usually homeowner association driven, whereas your sectional schemes like your flats and your duplexes and simplexes, those are normally sectional titles. They're grouped a lot closer together and not as independent from each other. But the principle is very similar. They're very similar notions. They just govern differently depending on whether they're freehold or they're sectionalized. All right, so this is a crucial step in the transferring process. Once this is achieved, the conveyancer has actually done a lot of the work, and this is often where you find the delays. Now, another job by the conveyancer that we also need to be aware of is they're also guardians to the contract, to the OTP. So whatever is in this contract, the conveyancer will have to be aware of and will have to enforce. So, for example, certificates of compliance, for electrical certificates of compliance. The conveyancer normally takes it upon themselves to ensure that before transfer takes place, that there is a certificate of compliance that's been provided to the new owner of the property. Okay, so it has to be a registered electrician. So there's a particular board that they have to be registered with, and you'll see from the document that's complete that they have to complete, that it specifies exactly the requirements. A lot of conveyancers actually have their own team of people that are more than willing to assist at a certain fee. The ultimate person that's responsible for the certificate to be issued is the seller, however. In fact, as part of our laws, it's a requirement that before you even market the property, that you should be getting a certificate of compliance, electrical certificate of compliance, before even marketing or selling the property. We do find on occasion that if, for example, the seller doesn't have enough funds to be able to afford the payment of such a certificate, that the purchaser can opt to pay for it and even appoint their own service provider. But ultimately, according to our law, that certificate needs to be in existence before transfer takes place. And that's also a very crucial step in the process of transferring the property. Look, at this juncture, so obviously different property transactions go at different paces. So I'm speaking very generally, I'm speaking very simplistically to say that, well, now that the attorney's actually done these things, and in the process, the parties have signed all the documents, because obviously now the conveyancer has to actually register this property and register the transfer. So there's certain documents that they would want to prepare that they need the seller and the purchaser to sign in order to authorize them to pass transfer and in order to actually effect the transfer itself. So it's not just the deed. It's also the documents that the deeds office will require. Now, these are all very formal documents. And as a buyer and as a seller, I wouldn't worry too much about the technical aspects of each and every page of these documents, provided that the conveyancer has actually advised you appropriately as to what you're signing. Similar to the bond attorney, there you're signing documents to register a bond. So you'd want to understand the nature of these documents. But these documents are the documents that are going to the deeds office. It's the documents that the deeds office needs in order to be able to register the transfer of the property. And it's at this juncture where the attorneys approach the deeds office and lodge the documents at the deeds office. Now, the deeds office has its own processes, and you'll normally find that the transfer process takes about 2 weeks to completion, and it goes through different stages and different places at the deeds office. But this again is a very technical aspect because it really it's different people verifying that the correct documents are in fact in place, that the correct documents have been submitted. Sometimes it even comes back with an objection that the conveyancer needs to fix and submit again. But ultimately, you've got the lodging stage, and now you wait for all the feedback that you need. The prep stage is just before now the attorney gets notified that everything's okay and it's time to actually take these documents, submit them, and have the transfer registered. And then finally, you've got the registration stage. And you'll find that the registration of the transfer happens at the same time as the registration of the bond. And this is the date of registration. This is when you get your notification from the conveyancer letting you know that your transfer has been registered. You are now the new owner of the property. Congratulations. Everything's in order. Now, there are a few things that happen after this. So you won't find that the conveyancer simply disappears at the stage. They will typically advise you as to how the funds were allocated. They'll advise you as to whether you can expect to receive a refund. So remember, since you're paying projections to the municipality, the seller pays projections to the municipality, you may very well find that there's certain amounts that might be refunded because it's been overpaid, certain amounts that might be due by the purchaser. So there's basically an accounting aspect that takes place after the transfer is registered. This takes 1 or 2 days afterwards, but usually at this juncture, the transfer is done, and yes, you own a new house.